Hi, everyone. Welcome to today's webinar, Preparing to Buy a Dealership with Legal and Tax and Market Insights. My name is Kathy. I'm the organizer for today's session, and I'm really glad that you all could join us. For those of you who may be new to us, at Rosenfield Company, we're a CPA firm that we work closely with auto dealers. We don't just handle the numbers. We like to help dealers tackle their day-to-day challenges of running and growing their business. And we host these webinars each month. We like to connect dealers with industry experts, help spark conversations that help you make more informed decisions for your dealership. And today's topic is all about the buy side, what to think about before purchasing a dealership. From market trends, legal requirements, financial tax considerations, our panel is going to break down what buyers really need to know before taking the next step. And we've got a great lineup today. Faris Syed from Sars Partners, Charles Gallaer from ArentFox Schiff, and our very own Ginsberg. And as always, we have Alysha Webb, who will be moderating and keeping the conversation flowing. And just a quick reminder, this is meant to be an open discussion, so please use the Q&A chat feature at any time. And with that, Alysha, I'm going to hand it off to you.
Thanks, Kathy. Well, we've been having a great conversation before the webinar actually started. And, of course, I've worked with Faris and Charles for many years on various capacities, but I'm excited to hear their insights. And Alan, of course, comes at it from the tax side, which is super important. So I think we have a great lineup. And with no further ado, I'll turn it over to whoever is going to start. Kathy would know that. And remember, all you listeners, ask questions. I always have questions, but I prefer it if the people participating also bring in their unique points of view.
Faris, I'll go ahead and give you the floor if you'd like to get started.
Yeah, hi, good afternoon, everybody, and thank you for taking time, Charles, Alan, Alysha, and Kathy, and our dealers as well. So some of the stuff we see on the buy side right now, there's a lot of different uncertainties going on with the dealers' interest rates, OEM pressures, and tariffs are reshaping the deal structures. So as the current administration, when it came in, we had a lot of talk about tariffs. And for lack of a better word, I have so far not seen, talking to a bunch of dealers, and Charles, you can jump in as well, is we haven't seen much impact on the market as of yet. As many dealers I've talked to, they have not seen when dealers are buying or selling the deals that, or when the sales are being affected by the tariffs. Are the OEM pressures going on with the facilities? They always are. When your facilities are getting old, the OEM is going to pressure you to spend money on your facilities. And the interest rate, as they have gone down in the past couple months, will they continue on going down more? We don't know the answer. But that is going to affect the market, and it has affected the market, I think, in the past several years. And we live in an up and down situation all the time. But the dealers are very they adapt quickly. We have seen that through COVID. We've seen that before COVID and after COVID, and we are the adapting bunch, where we take the market condition and make the best of it. So which shifting demands, which franchise regions are hot and which aren't? In our business, I think Florida and Texas are the hottest markets for us, where we have a lot of dealers from outside Florida. We get phone calls from all over Midwest and Northeast, where a lot of dealers, they have their residences, they have their homes here in Florida, where they like to have franchises, and we'll get a phone call and say, can you find us a particular brand in Northeast of Florida or Southeast or maybe on the West Coast of Florida. So we get mandated by some of the dealers, and we're looking for certain geography, we're looking for certain amount what they want to spend on the dealership. And mostly they are 99% of the time, they are current dealers in their home markets, but they're not shifting everything down to Florida. But they do want to have one or two different franchises in our markets where they can have a home and also have some of their management teams in place as well. The third part is the EV investments and new technology are influencing the valuations, which is a great topic, because for the past several years, when Tesla came into the picture, and General Motors and Ford and a lot of our OEMs, they have mandated the dealers to invest in their EV infrastructure. And some of them were subsidized by the manufacturers, and some of them are not. And they're not cheap. They are anywhere from $250,000 all the way to $1 million investment to spend money on it. But the dealers they have spent the money, and they have accommodated what the OEM is asking for. But what happens when they are selling the dealership? Are they going to get that money back, or are they going to be asking that money, looking for some kind of a rebate back onto the financial statements? So that, I think Alan will be able to help us with that amount. That is it something which is they're looking at when they're buying or selling the dealership? But on our end of it, on the buy sell side, we don't have that discussion to where, hey, I've spent $1.5 million on the EV infrastructure, and I should be getting a multiple of that. That is not a discussion which we usually have on our side. And longer timelines and more complex negotiation compared to past years. We were just discussing with Charles that a lot of deals are changing hands right now, but how many deals are actually getting to the finish line? It's a big question mark. And it could be a lot of things where the sellers' expectations are a little bit more than what they should be. Have they adjusted to the market after COVID, or they're still thinking about they should be getting the investment back what they've spent, or the store has been very profitable after COVID, and are they looking for the returns after the fact when we have for the past 3-4 years? So some buyers are going to come in and they'll say, no, we're going to look at post-COVID and pre-COVID numbers for the past 6 years to be able to make a good offer. Or some of them are going to say, we'll look at for the past 24 months, and that will give us a good number for where we can make a good offer for the store. So it's a mixed bag. And we accommodate that as well. We go back to the sellers and let them know, hey, this is what the expectation in the market. And it's been a busy market for the past since 2025. Next slide.
Next slide. Faris, did you want to touch on this slide? Or
Faris, you're muted.
Oh, I didn't notice.
Can you hear me?
Now we can. Yeah.
So diversification across brands, regions to balance risks. A lot of dealers who are coming in, they're looking, if they have 4 dealers, they have 3 or 4 different dealerships or GM dealerships. They're not going to invest in the same brand, and they are not looking to invest in the same brand. And they always, every time when we have a request, it'll be a different. If they are domestic, mostly they prefer to go into the domestic side, but some of them prefer to go into the imports, which is your Toyota, Honda, not as much as Nissan and CDJR. So yes, they are looking for diversification across the brands to balance the risk and also diversify their portfolio. Motivations behind acquisitions could be varied. Growth, they want to grow their portfolio from where they are because it could be several reasons for it. Either they have their son or daughters or their family members into the business, so they want to grow the business into different markets. Consolidation, where if they currently have a store, for example, in central part of Florida or some other location in Georgia, they want to consolidate within the same market to get economies of scale, where they can have a single service manager, or they have a comptroller, or they can also use their salespeople and the cars. They are moving back and forth as well. Succession planning is a big deal if they have their family member into the store and they are reaching the age where they're looking to diversify, and they're also looking for their son or daughters into the dealership. They're going to be having that discussion with their CPA, with their attorney, investment banker, or the broker, that how do we go about having them involved with the dealership. The key metrics buyers are tracking: profitability, absorption rate, return on investment. I think I will go backwards where return on investment is a big deal. They're looking, obviously, they're investing their money to maximize the return on investment. And how much upside potential in the acquisition they're going to be making is a big deal as well, where if the store is underperforming, they're going to do their due diligence. They're going to find out what is missing. Is the used cars are not being sold properly, or they're down on new cars, or the absorption rate, or the service department has a lot of potential. I think that will be another factor where the dealer is going to be looking to grow. Franchise mix, location, and inventory trends is also impacting the deals. What kind of franchise is a dealer looking for when a buyer comes in? They're looking to definitely diversify from the portfolio what they have right now. The top brands, as we look at the Blue Sky reports right now, the top brands are imports: Toyota, Honda, and the luxury brands. We have a lot of dealers looking for luxury brands, which are very hard to come by. And if they're looking for the most amount of money you can probably pay in major markets. So we do have a lot of requests on that as well. Next slide, Kathy. So how do you prepare before you enter the market? You build the right advisory team, including your broker, your attorney, accountant, and lender. So where do you start the conversation? I think your conversation usually starts with your CPA to how you're going to have the investment, your best use of your investment. Your CPA, your closer confidant, because you're talking to them on a daily basis, and looking for a team of CPA who has automotive knowledge. That is the number one key thing which we advise to our dealers as well, that unless you have two different CPAs, one is doing your taxes on a daily basis or a monthly basis, and you also have a CPA who's doing you're taking your dealership and also doing your business taxes and stuff like that. So that will be your number one person to go to start having that conversation. The second part is your attorney, which is in our business is very, very important, that which legal team you put together, because your current attorney who's handling your real estate, or your current attorney who's handling your other family matters, we advise to get involved with a M&A attorney who's specifically into the automotive buy sell, because they know the business, they know what are the pitfalls, they will know everything, how the deal can be made, and also you can make the right decision on choosing the franchise, and they will know the CPA. They will connect you with the CPA and the broker who will help you find the right franchise and in the right market. So those two individuals, which is your CPA and your legal team, is probably, if you choose those right individual, they will help you find the right broker. And broker, obviously, you want to ask those questions, that how much experience do you have, and how many deals have you done in the past, and where's your experience come from, how long you've been in the business, those kind of questions. And I think it's very important for you to put a right team together to be able to acquire a dealership. Tax and accounting factors to review before making an offer. Like I said, a CPA and a accounting team is very, very important to work all the way from start to finish, where they can look at your financial statements, also give you a bottom line from revenues to gross profits, and what are the different areas of opportunities you should be looking at. They can actually give you a very good view of which dealership and if it's the right choice for you as well. The importance of due diligence, understanding the total acquisition cost. Like I said, your accounting team and legal team are your best friends. Next slide, Kathy. So I'll turn it over to Charles on the legal framework.
Yeah, thank you, Faris. And I just it's always fun to do these presentations, and I thank everyone for the opportunities to be here. I think we've assembled a great panel here with a lot of industry experience, and hopefully, whenever I go to these things, I always say to myself, well, if I can walk away with at least one thing I didn't know before, it was mission accomplished. So hopefully, we're going to give you a lot of things that you didn't know before to make it even more of a productive conversation. Before I go through my slides, I want to touch base on a couple of things that Faris just brought up in the previous slides. We can stay on this so we don't have to jump around. And just to highlight again the importance of having the right team as you're going through the process, it's critical. I mean, and I'm not just tooting my own horn because this is the law practice that I'm in, and I do concentrate on the automotive industry. I also do transactions in other industries as well, and I can just say that this particular industry has a lot of inside baseball, to use that term, that you really need to know to be able to navigate a successful transaction. And that goes from not just the broker, but also the accountant and the attorney. So let's, you say to yourself, well, a broker, how important is that? It's critical, right? Getting the right broker so that they have the acumen and the ability to negotiate the deal, that they're familiar with the particular markets that you may want to operate in and looking to make acquisitions. They're familiar with a lot of the business terms that are being negotiated and what may be on market or outside of market. That's a huge help to have the people that are in the right area. And sometimes, on the broker side, you'll see folks that are a little bit more region specific, and that's great to use those folks if that's the region you want to be in. But it's really important as you're going through that vetting process and deciding which broker you want to work with, is having one that you understand they're in the markets that you want to make acquisitions in. That's critical, and they have experience in those markets. From the accounting standpoint, again, you think to yourself, well, a CPA is a CPA. I would respectfully disagree. It's a huge difference having somebody who is not only has that CPA qualification and the all of the different bells and whistles like the AICPA and all of those credentials, but actually also the folks being able to apply those and understand the car business in and out, and they can help guide the process. I'm sure Alan will chime in, but guys like him are the ones that help you find where the bodies are buried in a transaction when you're going through the due diligence. And there's certain accounting, I don't want to call them tricks because that sounds negative, but there are certain accounting practices that we have in the automotive industry that if you're not familiar with the automotive industry, they're not going to understand it, or they might completely miss it. And then finally, as the attorney, that again is critical, having somebody who's not only skilled in mergers and acquisitions and understanding the ins and outs, but really being in tune with what's going on in the auto industry. I wear two hats in my practice. I work on transactions and I also do litigation. And I was just telling this to the panel before we went live today. I just finished up a jury trial out in California over a buy-sell that went bad, and my firm represented the buyer, and we were a huge component of that case was the contract and terms that were in the contract. And the seller was represented by a law firm that this was their very first dealership transaction, right? And so, again, not saying that every single time that an attorney does something for the first time, it's going to end up in a lawsuit. But as a transactional attorney, I can tell you the one thing that I would dread is having my contract at issue in a lawsuit. And there's certain things that, with the benefit of hindsight and having people that know the terms of the contract, there are things that could have been put into that contract to avoid a lot of the disputes that we face there. So that's my little plug for everybody else that is to piggyback off of what Faris had said, is very important to get the people that are really skilled and know what they're doing. And so let's go into the legal specific slides here. As you know, this is a highly regulated industry. Car dealerships are in the automotive industry. In most states, the only other industry that's as regulated as highly as this one is the beverage industry. There's a lot of similarities between dealerships and the distribution of alcohol in states, and so there's layers of licenses that you have to get. Most states don't allow direct sales of cars. Same thing with alcohol. So there's a lot of similarities where this is a very regulated business just on the state side, right? So each state has its own different laws that you have to navigate as you're going through the process, but also the OEMs, right? They're a huge factor that you have to deal with in any type of transaction that you're doing for a dealership. You have to have in your mind, what is it going to take to get the OEM's approval? What are the requirements the OEM might put on the buyer? What are some of the things that the seller has to resolve before they can get consent from the OEM to transfer to the assets? But again, that it's a very highly regulated industry. Each one of the manufacturers kind of does their own thing, and you have to know what you're doing and being able to contract and notice where these particular issues may flare up with requirements of the manufacturer, how much time it takes for them to approve the deal, their review process, whether or not they can exercise what's called a right of first refusal, and they can come in and step into the place of the buyer and take over the deal. Asset versus stock purchase is really the way that we see most of the vast majority of these transactions, with almost all of them being some type of asset sale. I also included the term contribution because one of the things that we're seeing in certain types of transactions now is instead of a buyer actually purchasing the assets outright, they enter into an arrangement where the assets of the seller are contributed to a new company, and then there's consideration that's paid for that. So there's creative ways that the deals can be structured, but for the most part, it's going to be, I would say 95% of the ones I see are asset sales, and then with a very small percentage of being stock sales. And again, your attorneys can walk you through and tell you what the differences are and the things you have to be mindful of as a buyer, because it's actually a big deal in terms of liability for what can happen. Phases of the transaction: negotiation, execution, pre-closing, closing, and post-closing. I made this as simple as possible, put them into these nice 5 buckets. But there's a lot of steps that go into each one of those. And having, at the beginning of the negotiations, are you going to have a letter of understanding or letter of intent? What are the terms of that? Are you going to have it where there's provisions of that are binding or not binding? Who's going to draft the contract? Then we move over to the actual contract and execution phase, where your attorney, hopefully we've convinced enough people that you should do this with an attorney, and that's a given. You shouldn't be doing this on your own. You should focus on getting people that can help you do this and keep you safe. There's going to be the back and forth with the negotiations there. And then once you actually get into contract, you have to, there's this period of time between when the deal is signed and when you're actually going to do your closing, right? And there's a lot that has to happen in that period of time. Depending on how you structured the deal, could be when you're doing your due diligence. It could be when you're getting your title reports, your phase ones, your phase twos, you're doing financial due diligence. There's certain things that parties are going to be responsible for delivering so that we can get to the point where we're ready to close. And so having all of that documented and having it where all of the parties clearly understand what's going on is critical. And then it gets us into the post-closing phase. When you go through the closing, what happens then? What obligations does the seller still have? Does the seller just take the money and they're off in Tahiti or Puerto Rico or wherever it is? Is the seller going to stick around at some point? Is there some kind of indemnification that continues after closing? Again, all of this has to be considered, because as the buyer, your goal is to make sure that whatever you've negotiated for is what you're going to get, right? Nobody wants to pay X amount for something thinking it's worth X amount, and then come to find out it's actually worth a lot less than that. So again, having the people in place that are going to help you through the negotiation process, doing your due diligence, getting the contract signed, and knowing what your rights are and having those clearly articulated in the contract, that's critical. Next slide.
Faris, did you mean to raise your hand? Did you want to add something?
Yeah, I just wanted to piggyback on what Charles was saying. A couple things. One is, it's such an important point, Charles, you brought up as having the right attorney. Because if they're not, every time over the 250 some deals we have touched, the few deals which we have not been able to commence is because of the attorneys. They didn't know what they were doing, and they get up into a place where they just don't know how to communicate between the CPA team, the broker team, and going back to the OEMs. and they couldn't advise properly to the dealer as well because they don't understand the world of M&A into the automotive team with the automotive buy sells. And on Alan's side, we have had some of the deals. An example is we had a dealer who had their trust, or a lot of dealers do have trust involved when you have such large amounts, which we are working with. And if you don't have the right CPA, right investment banker looking at your trust, how much taxes you're going to pay, or what are the tax ramification, or how much money you're going to bring into the bottom line, and then once you take that money, what are you going to do with it? And if you don't have the right advisor and they have given you a total framework of how much exact money you're going to be taking to the back, that could blow up all the way to the end, because once you have that and you go back on the closing table, you say, well, I'm taking $20 million in. However, half that is going to go to guess what? That deal is not going anywhere. So it's so important to having a team, which a good broker who has a good relationship with the sellers or buyers, and they are communicating between the CPA team, your investment banking team, and also your attorney. It's a recipe for a deal which can happen or which won't. So that's all I wanted to add to this.
Yeah, thank you very much. And I can assure everybody, I didn't slip like over some Bitcoin or something to Faris to tee it up like that. We didn't rehearse that, but that was perfect and plugged some things, and some very critical things that you have to consider. All right, so we're on to the next slide. Key legal risks, right? I want to boil, you don't put up all the legal risks, because as an attorney, then we freak people out, and then everybody would just huddle under their bed and they would never do these deals. But the fact is that plenty of these deals transact, plenty of deals go through without a hitch. And again, a lot of it that occurs when there's the right people that are advising folks, and everybody clearly knows what their obligations and responsibilities are, and it's papered. The deal gets papered properly. But in my practice, the things that I see the biggest risks are boiled down into these 4 bullet points, and I'll go through each one of them. First is franchise obligations, and I put that in scare quotes because a lot of this is there's different things that go into whether or not an obligation is actually something that the buyer has to do for the deal to close. There's state laws that pertain to things that a manufacturer can and can't do as part of the review process for approving a buyer. That's going to be very, very state specific. So whatever state you're in, it's important to talk to not only somebody who's knowledgeable on the automotive business, but also that particular state's franchise laws, or we call them dealer acts, in understanding what manufacturers can or can't require of an incoming buyer. Because again, as I think Faris said it earlier on in his presentation, they're like, for example, facilities, right? So you have a buyer, you're the buyer, you're coming in and looking at the facility, and you're like, hey, this facility looks good to me. Well, that facility could be on a prior image compliance program than what is current, right? So the manufacturer may not have actually done something to the seller to make them renovate their facility, because maybe they couldn't under state law, right? Maybe there's some laws, because some states have laws that will say, okay, you can only require a facility upgrade under certain circumstances. But a lot of that could actually go out the window for the buyer, right? So you're the buyer, you're like, hey, this facility looks good to me. And then you come to find out they're like, oh, no, you're going to have to spend another $5-10 million to make this image compliant. And so whether or not they can make you do that, whether or not you have any rights to challenge it, that really will affect the outcome of the deal. And I've seen deals blow up over facility requirements where somebody didn't take that into account when they were doing the deal, either from the buyer side or the seller side. Another big issue is the real estate. This is a dirt business. We're selling cars, but actually, ultimately, it's like McDonald's. Ray Kroc was famous in his movie. It's like, you're not in the hamburger business, you're in the real estate business. Car dealerships, same thing. They're in the real estate business. They happen to have a car dealership on top of it, as opposed to selling hamburgers. But ultimately, you got to have an understanding of what the real estate component is, because all manufacturers are going to require that, right? Not only are they going to require you to have some type of real estate, but it's going to have to meet certain size requirements. There could be number of parking spaces, number of different things, that you have to take into account with the actual, not just the image of the facility, but the dirt and the layout of it. So you got to know all of that ahead of time, understanding whether or not the seller owns the property outright? Does the seller lease it? What are the terms of that lease? What are can you assign the lease? Do you have to do it as a sublet? I'm just throwing all this stuff out here because we could actually do a whole seminar, multiple hour seminar just on real estate and how complex that can be. But again, these are the kind of things that you have to look for because those are landmines that unsuspecting buyers can get tripped up on, thinking that there's a real estate component that's all been satisfied, but in fact it's not. And I also put the term in site control here as part of the real estate component. Not sure I have the level of people's familiarity with that, but when I'm using the term site control, I'm talking about some requirement by the manufacturer that the property is used as that particular brand's dealership, right? Again, that's going to vary from state to state whether or not they can require it. And it's very brand specific too. Some brands don't care about that at all. Some brands are very, very sensitive to having site control because they have concerns that, the dealership might be on a very high trafficked area, very valuable piece of property that may be better off for some other use other than a car dealership. And that could mean they exit out of the market. So again, that's something you got to be really understanding of. And Sarah, funny stories come up, but they're not so funny at the time when they happen. I've seen plenty of instances where, that rears its head at the closing table where all of a sudden, the seller forgets that he or she signed a site control agreement 25 years ago. And it's a site control agreement that goes on for 30 years. I could say that my own dad did that when he was selling his dealership. I was, that happened and I was the attorney on that. So that was a lot of fun. So we got through it. Everything closed okay. But, that, and it's not just him. I've seen that happen plenty of times where that just pops up. And then it's normally in the process of when you're going through the franchise approval, where all of a sudden the franchisor, the manufacturer says, "Oh yeah, by the way, as part of this, you got to assume the site control agreement." And as the buyer, you're like, "What's that? I don't know what that is." So again, keeping those things on the radar, being able to flesh that out in the due diligence period, or even before you get to that, making sure your contract is getting some type of disclosure from the seller, affirmative, a warranty and rep, or something that comes out and says, "Hey, this is out there. You need to know about it," and have that factor into your deal so it's priced in. Employment and workforce transition. Again, this is a very state by state thing. I know Faris had mentioned that Texas and Florida are big markets. We're seeing the same thing too with a lot of transactions. We're also seeing a lot of transactions in California. That's one of those where California is the largest. It's the largest car market in the United States. It's the largest state by population. So there was some activity where maybe people were not as excited about going into that market, the state, or expanding, but we're seeing a big uptick in that. And that's certain states. There's federal laws that deal with employment and workforce transitioning, and then states. It's a very specific state by state thing. So you have to understand what's going to happen with the employees, who's responsible for what, up until what period of time. Are you going to retain employees? Does the seller have another dealership that they want to move some of their employees over to this dealership? All of that has to be considered. And then last, compliance, and that's a big umbrella where we talk about the seller's compliance. You're really concerned about that. And you may say to yourself, well, what do I care? I'm taking over the dealership. That's on the seller. If the seller was compliant with F&I or data privacy, you don't want to have it where you go into as the buyer and you're going into a store post closing and you find out that, for example, all 35 of the desktop computers are running an illegal version of Windows. You say, hey, how's that happen? How'd it happen? Fortunately, I've seen that happen. Seen it that the intellectual property, the dealership's using like a TikTok account or they're using Instagram, and who gets that after the closing? What happens to that? Do you have it where there's certain branding that you were thinking as the buyer you were going to be able to hold on to, but the seller says, no, I'm keeping that. That's an excluded asset. Again, with the compliance, if there's a bunch of people that are waiting after the closing at your front door saying, hey, I was ripped off by the seller, it's not a whole lot of comfort for you to say, hey, go talk to the seller, because it might not be your fault, but it becomes your problem. And so making sure that you have that on your radar. And as the buyer, do you have indemnification in place? Do you have different mechanisms in place to protect yourself from those type of unforeseen things that come up post-closing? And the question here is, what's one risk area buyers often underestimate? I would just say that they I would say I could break it into two buckets, right? The ones that are new to the car business, I think they underestimate how much time it takes to get the OEM approval and how the OEMs can throw wrenches in the works. And that's just for them, it's a learning experience. And if they don't have attorneys or brokers or accountants that can help them through that process, that can be a very rude awakening for them because again, they're thinking to themselves, I'm just going to buy the dealership and 20 days later, 30 days later, I'm selling cars.
Mhm.
And that just doesn't happen that way. And that's a wake up. I would say even more experienced buyers, the one that's the risk is that they underestimate is the compliance risk. And then a part of that is you don't really know until you get in there where the skeletons are. As much as you do your due diligence, you could certainly uncover a lot of them. And the stronger your contract is and the stronger your team is that's working with you through the due diligence process, they can help you find where the bodies are buried. But ultimately, if somebody's a crook and they want to hide something really good, it gets hidden. And so it's making sure that you have some type of protection post closing where if those things start popping up and rearing their head, you have some mechanism to try to offset the losses that you have and you're not left just holding the bag. The next slide. Oh, I'm sorry, Faris, I see your hands up.
Yeah, Charles. On the real estate side, just wanted to add something. I think the another phenomenon maybe we run into is that the REITs, the real estate REITs, come into the picture, and we have run into these cars and legacies and all these guys. They come in, they have a 25-year contract on the real estate, which is away from the OEM site controls and real estate if it's owned by the seller himself. Now you have REIT to worry about and negotiate with, and they have very, very strict contracts. They won't let you out no matter which way you look at it. So that can complicate your deal as well, which is another point going back to who your attorney is, who's your broker is, and who's your CPA team is, because if you don't identify these mine pits in front of you, it'll either go smoother or it won't go any smoother. And on the compliance side, we had a deal which we had oil changes for life inside the deal. So how do you address that? Because now you have 100,000 or 50,000 clients out there which are looking to come back to the dealership for as long as you can imagine, but we don't know what the end of that oil changes for life is. So these has to be addressed right up front. And a good CPA and having a good attorney and a broker, experienced broker, that will make sure that pinpoint it for you before you go in and make that much investment.
Exactly. Well said. All right, so structuring and closing the deal, right? That's what we're all here for. You don't, as the buyer, you don't spend all your time and energy and hire a bunch of professionals to just talk about deals. You want to close them, right? So a couple of key points to keep in mind on the purchase agreement. Again, I use the term purchase agreement because you're purchasing something. You're either buying the stock or the assets. Again, most of them are going to be asset sales. A key thing to structure as you're going through out of all of the different ones are reps and warranties are super important, right? That's one of those where as attorneys, some folks have a habit of just kind of falling into a routine where you're like, oh, this is what we would call boilerplate language, which it's the same for each deal, but it really isn't. Like I said, for example, with that site control thing, right, where we were talking about that earlier, or as Faris brought up with the REIT, that all of that should be if you're structuring the deal and drafting your APA correctly, you're going to have that disclosed as a warranty and rep. So that's not a surprise. I hate surprises, right? Like birthday surprises, that's okay. But if I'm representing a client and I'm doing a buy sell, I don't want surprises. I want it to be like, in and out 20-minute adventure, have everything figured out and no surprises when we go to the closing table. I don't want things renegotiated at the closing table. I don't want to find out about something at the closing table that I didn't know about months before we got there. So again, getting these, spending some time on the warranties and reps, spending some time as the buyer, getting the seller to tell you, for example, are they under a notice of termination with the franchisor? Is their facility compliant with the franchisor's current image programs? Did they receive any special money from the franchisor that would affect earnings, quality of earnings estimates that you may provide? Getting all of that fleshed out and spending some time on that, making sure that you understand what you understand as clearly as possible where things are, where things could blow up. And a great place to do that is in the reps and warranties. Third party consents, Faris and I talked about this before with the REITs and landlords and the OEMs. That's huge. And there's other parties too, right? Like vendors, for example. Like let's say you're going to take over the seller's DMS contract, right? People do that. And what does it take to do that? What are you going to have to do to get consent from CDK or DealerTrack or whoever it is to come in and say, okay, day one, you're going to be able to switch everything over? Because the last thing you want to do is to find out at the closing table your phones aren't going to work for 3 weeks because there was some form that you were supposed to have signed by the vendor and you were supposed to sign and get to the vendor and you didn't do that. So understanding all of the different parts of the business, and if there's anybody other than the buyer or the seller that could affect those transfer of those parts of the business to the buyer at the closing, is critical in making sure you line up their consents ahead of time. With the landlord specifically, that's a really funny one, and that's very region specific. Like here in New York, and specifically in New York City, it's not uncommon for you to have a dealership where the property is owned by somebody else and then the dealership is owned by somebody completely unrelated. So the landlords can be a 100% wild card, and depending on what the lease says or a sublease or whatever it is, that could be highly negotiable. It could be take it or leave it, or the landlord could just blow it up and say, I'm not going to do this. I have no obligation to do this under the contract. That my lease, you're out of luck unless you pay me quadruple the rent, and you're stuck with that. So just understanding all of those type of things before you get to the closing table, and normally, ideally before you even sign the APA, but having it where you could at least find it out during due diligence and giving yourself a chance to get out of the deal if things aren't quite like what you thought it was. And why do we do all this? Why do we put all this work into structuring the contract, doing the right due diligence, making sure everything's up front and in there, is so that we can have a smooth closing. I said this earlier. I am not one of these kind of guys where I like to go in and have a lot of uncertainty at the closing. I think it wastes my client's time. It wastes the broker's time. It wastes the financial consultants and the accountant's time, and it just looks bad, right? It's like one of those things is I'm thinking if I was a buyer, I wouldn't want that. I'd want it where my professionals have everything buttoned up so I can come in, sign the paperwork, shake hands, say, okay, let's wire the money. And after the car, once the cars are counted, wire the money, everything's good to go. So that's why we do all of this. And a question here is, what helps ensure a seamless handoff at closing? Is preparation, 100% preparation, and making sure that you have everything set up in your contract from the start correctly, making sure that your due diligence is all done and dusted by the time it needs to be done, so that you're educated on what things are that you're buying and you know what you're buying, and having everybody clearly understand. Again, normally this occurs through the APA. Ideally, it would occur through the APA, the terms of it. Understand who's responsible for what at closing and when those deliverables need to be delivered. Next slide. So I always like to try to end something on like a meme or GIF or whatever. I'm like a Redditor. I like to have things kind of fun to bring people back. I had to look this up because I'm famous of getting people's quotes, and then somebody tells me, well, actually, that person didn't say this. So I checked this, and I believe this is accurate, unless somebody could show me something different. But Mike Tyson, right, famous boxer, it was quoted as, everybody has a plan until they get punched in the mouth, right? And so that's kind of where we are with this business, right? We have plans, and then things happen. That's the punch in the mouth, and things can happen, right? No matter how well you have your contract drafted, no matter how much due diligence you have, no matter who you have working for you, things can happen. And what's important is having people in place that can help you. So when you do get punched in the mouth, it's not a KO. You're able to come out and you can still close on the deal and get exactly what it is that you wanted. So again, we can do everything we can to get you prepared. Things can come up, but it's a matter of having the people in your corner, being the people in between the rounds, giving you the advice so that you can get back out there and you can do the KO and close the deal. So that's it. I think, Alan, I hand it over to you now.
Yep. Okay. As the accountant, I'm the guy you go to do all the detail work to make sure that this is, actually a good deal for you and that you want to go through with it. The most important part of that is the initial due diligence work. You want to make sure that the numbers you're seeing are the numbers you're actually getting. It's not unusual for a factory financial statement to reflect numbers that might have stories behind them. So you want to get to those stories and find out what's real and what's not. In regard to that, you want to look very closely at the balance sheet, specifically in terms of what are you buying in terms of inventory? Are you, for instance, buying parts? If you're buying parts, then you want to make sure that they're new parts, fully returnable in original boxes, and parts from the OEM and not aftermarket parts. Also, you're going to be buying the fixed assets. In regard to that, what's the condition of the fixed assets? Are they still usable? Are they worth anything? Or have they been laying around collecting dust over the years? The next important part is evaluating the purchase price and the allocation of that price. It's very important from a tax standpoint. What are you allocating to goodwill versus fixed assets? That can have a major implication on the tax implications that you're going to be dealing with in less than a year down the line. In regard to goodwill, that's for tax purposes, will be a 15-year asset versus other fixed assets, which can have a much shorter, not necessarily lifespan, but the ability to write off what you're paying for it. Then you have the reconditioning cost of the used inventory you're buying. For instance, you're buying used inventory, but how much are you going to have to pay to make that inventory sellable to the end customer? Kathy, next slide, please. Then you want to deal with what's going on in the dealership. There are various checklists that we use to look at the various financial areas as well as other areas for the dealership. We'll be giving a link further on in this presentation so that you could take a look at that checklist. We're certainly more than happy to help any buyer of dealership with that checklist, or it's something that you can use yourself, or even possibly give it to your accountant who will be doing the closing. But we strongly recommend that even if you choose not to use us, that you use another accounting firm that actually specializes in dealerships, so that there are no surprises at the closing table for you. Another important area is for working capital adjustments. When you're looking at a deal, you might say that, hey, I have this certain amount of working capital I have to deal with, but working capital amounts can change based upon the dealership you're buying and the value of that dealership. You basically want to make sure that should you need some additional working capital, that you have potential sources to go to get that added working capital. Another important area that I just want to mention is the tax structure of the organization. Depending upon what state you're operating in, you might want to form either an LLC or an S Corp. And that's something that you want to have numerous conversations with both your accountant and your attorney to determine what the best tax structure is in terms of the state you're planning on operating in and the specific challenges you might face. There are plenty of other situations that you're going to want to deal with in terms of your accountant, in terms of buying this dealership, and you know, you're going to have various conversations with them, probably also with your attorney and your broker, and it would probably be best advised to have the three of them meet with you on a regular basis during the entire process. Next slide, Kathy. This is the link I was telling you about, where you can actually look at the due diligence checklist. Feel free to contact us with any questions you might have on it. Anything else, Kathy?
Thank you. I'm going to take us to our final concluding slide in case any of you guys have some final remarks. And Faris, I just saw your hand up, so you go ahead.
My hand's been up from the start. I'm sorry. But Alan, I got a question for you on I run into this a lot when we look at the financial statement stuff. Obviously the seller will always want the best price for the fixed assets. How do you treat the fixed assets when they're depreciated 100%, when they have depreciated everything down? How do you on your side of it, on the accounting side? Because obviously they're gonna want they want, hey, listen, my machines and all that, they're worth about $1 million, yet you've depreciated them already. So what do you do with that?
Well, they might not necessarily want that once you explain to them that if they're getting a large amount for the fixed assets, they might have potential recapture of prior depreciation, which would be at ordinary income rates versus capital gain rates. Goodwill would certainly be at capital gain rates, whereas fixed assets, a portion of that would be at ordinary income rates.
Mm-hmm. Okay, and the second question is on the DMS contracts, and Charles, that's for you as well, that we have ran into a few times on these extraordinary amounts from some of these bigger DMS companies. I'll name three. I'm not going to pinpoint one. I'll just say Reynolds and Reynolds. I'll say CDK, and I'll say Techion, whatever that means. But one of them is out there where they have, 25, 30 grand a month kind of contracts, CMS contracts. So, for example, a dealer has signed up 5-year or 3-year contract on a 25 grand a month. Now the buy sell comes in, and that is an obligation which Reynolds or whoever, that maybe they're not going to let you out of this contract. How do you negotiate on that piece? Because you got $1.5 million, $2 million on that agreement left over. For the buyer, it's very hard because now they have their current CDK or another third-party entity, which is much cheaper than the one they have. So do you see anything out there which can be addressed at all, or no?
I'll jump in first on that.
Okay.
That's one of those where there, depending on the DMS, we have seen some luck in some, not to say luck, but we've seen some willingness to have some negotiations on the buyout. Again, it's very specific from DMS to DMS, and some of them are much more difficult to deal with than others. And I think that's why it's just so critical. And this is really, from a buyer standpoint, if I'm the buyer, if there's going to be a section in the APA that talks about assumed contract, or there should be, right? So if you have people that are doing the deal the way that you should do it, there should be a section in there that clearly states which contracts are being assumed by the buyer and which ones aren't. And then there's normally some type of negotiation where the buyer gets to due diligence out the contracts and then gets to decide whether or not they're actually going to assume those particular contracts. So from the buyer standpoint, I think it's really going to depend on your drafting the contracts such that your APA such that you have as much flexibility in determining if and when you're going to assume a contract. As the seller, that's something the seller should be, when they're putting together their decision, their material and deciding whether to sell their store, they need to have that an honest and frank discussion with themselves, their legal counsel, the brokers, everybody about what are they going to do and what's the exit strategy with that contract. And getting that's another one of those where it's just because it's a third party consent that you need, getting out there and getting that information and getting it addressed as soon as possible just makes things easier. And I just thought about one thing that I'll hand it over to Alan so he can chime in too. Where this can rear its ugly head is that if you're the buyer and you're trying to transfer over the DMS from the old DMS to the new DMS, and then the legacy DMS is like, well, you're not assuming this, so I'm going to stick this to the seller. Then the seller says, I'm not paying that. Then the legacy DMS says, well, we're not transferring everything over. We're not transferring anything over. Seen it happen. So, it's like most of the stories I'm talking, it's just not something I thought about as we're talking here. It's because I've seen it happen, unfortunately. And again, that's just where you got to get, that's one of those, that should be on your radar if you're the buyer or the seller early on, well before you sign the agreements as to what you're going to do with the DMS and whether or not it can be terminated outright or there's some ongoing liability to the seller. Alan?
Well, if you're the buyer, you want to make sure you have your ducks in a row on this long before you're closing, because I've seen some nightmare situations develop, and what ultimately happens is they end up in lawsuits. And the goal of a closing is not to be involved in a lawsuit afterwards. So you want to do everything ahead of time to avoid that.
Agree 100%.
Alysha, I see your hand up there. You got a question?
I did. Of course, when you started talking about DMS, I thought CDK incident and cybersecurity. How does that enter into the discussion? I mean, obviously, you've both laid out, or all of you, issues that can occur. And as Charles said, some DMS companies are easier to negotiate or more difficult to negotiate than others. So how does the whole issue of cybersecurity and the DMS, how does that enter into structuring, the APA or wherever that comes in to the discussion? And I'm not sure who's the best to talk to about that. Faris and Charles, I guess.
Yeah, I can jump in real quick on that. That's something that's more and more on people's radars than it used to be. As to, the people are very mindful because more and more states are adopting privacy laws, cybersecurity requirements. The manufacturers have them. Your lenders may have different things that you have to do it. And I think that falls into the area of, again, like I was talking about earlier, warranties and reps. Having it where there's a warranty and rep that says, to the seller's knowledge, there has been no data incidents, and you can define what a data incident is. So that way it flushes it out. If there is one, get it disclosed early on in the contract, so that what you're dealing with. And then in your deal, as your APA, you're going to want to have something that takes all of those warranty and reps, and we call it a bring down, where you make it so that even though they're dated as of the date the APA is signed, they're actually renewed and effective as of the closing. So if there's a data incident that occurs from the time the APA is signed to closing, that then gets disclosed, right? So there's a disclosure to it. And the other key to it is indemnification. So making sure that your indemnification provisions in your contract have strong language in there that includes data breaches, so that if there is something that happens that would have been linked back to when the seller had the dealership, because sometimes these data breaches people don't realize it's a breach immediately. Maybe it takes a little bit of time to discover that there's a breach. Having it where there's some type of indemnification from the seller if the data breach occurred prior to the closing, not just that it was identified prior to, not that they find it, but that the breach that there's some protection in there that protects that buyer from basically up until the point it becomes the buyer's responsibility to safeguard the data then. Faris?
Yeah, Charles, on the same subject, on the reps and warranties, what have you seen, or what is common in escrows, that if a dealer, a buyer wants to put an escrow amount, does it vary how much, or what is the normal, and also how much and how long?
It is some of the people I negotiate against probably put you up to this. I'm teasing. That's something that's highly negotiated, right? Because I represent both buyers and sellers, so I can put my buyer's hat on and explain to you what different things you need for an escrow or some form of indemnification, and then I take that off. And if I'm representing sellers, then I put on a different hat. Because really, what are the parties' goals, right? The buyer wants to end up at the closing with what they negotiated for the price that they negotiated, right? The seller's goal is like the old Steve Miller Band. It's to take the money and run, right? They want to move on to their next lives. They don't want to have lingering things that are going on. And so there's some meat in the middle that has to occur. And that's where is it going to be some form of personal guarantee? Is there a corporation that's going, or an LLC that's going to continue to exist that can guarantee the obligations of the seller post-closing? Because most of the time what happens to the seller is they get wound up, right? So even if the seller comes in and says, hey, I'll indemnify you 100%, don't worry about it. 2-3 months later, the sellers, all their assets are gone and there's nothing to back up the indemnification. We do see, and this is something that I've seen more and more of these, where you have some type of escrow that's placed at closing, and not just in the car business, because I've handled transactions in other industries. That's actually something that's pretty common in a lot of other industries, is to have a certain amount of the purchase price that's held at the closing and put into some kind of fund that is sitting in escrow, and that there's drawdowns that can occur. Again, it's all negotiable, right? The period of time is negotiable. How much money goes into the escrow is negotiable. Whether or not the seller gets some of the money released when certain things happen or certain dates occur, that's all negotiable. I think it really is going to come down to, on a deal by deal basis, as to what level of comfort the buyer and seller want, and that varies from location to location, brand to brand, operation to operation.
No.
Great. Oh, thank you guys. We made it right to the end, so I'm gonna go ahead and wrap it up for today. But thank you if you're with us here till the last minute. And thank you to our panelists, Faris, Charles, and Alan. Thank you for sharing your insights today. And we hope this discussion gave you all some useful takeaways. If you'd like to keep the conversation going or learn more about how we could all help, feel free to connect with us. I've got the contact info here on the screen. And I'll be sharing a recording of today's session along with these slides by the end of this week. So definitely keep an eye out for that. And on behalf of everyone at Rosenfield, thank you again for spending your time with us today. We look forward to seeing you at our next webinar.
Thank you very much for the opportunity.
Thanks, guys.
Thanks,
Kathy.
guys. Great info. Thanks, Kathy. Bye.
Thank you. Bye. Awesome.